What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Friday, August 8th. We wrapped up Donna Adelson's final pre-trial hearing about an hour ago. First off, I am uploading a better version of this hearing. I've taken out the background noise. I've enhanced the audio so it's much easier to hear what they have to say. So that should be up in about an hour if you want to rewatch or watch for the first time. But we're going to break down what happened. I will say, I think based on some of the things the defense said, it seems really likely that Donna is going to take the stand in her own defense. It wasn't worded if she takes the stand. There were times where he said when she takes the stand. Now, not confirmed. Obviously, she could change her mind between now and then, and we'll see what happens. But y'all, that is going to be juicy, especially on cross-exam with Georgia Cappleman. So we'll see what happens once trial gets started and the defense starts their case in chief. They started out talking about the motion in limine about the divorce files between Wendy and Dan. The defense says some items have no bearing to this case aside from a very limited amount of evidence. Prosecutor Cappleman wants to admit the file in its entirety. She said it goes to motive and the level of intensity of the litigation, the volume of paperwork. It went on for a long time. Some of the words that are used are strong and hateful, and that's a cause adopted by Donna, which was seen in her emails to Wendy. She said Donna was involved. She offered detailed responses of how Wendy should respond and is bound to the state's theory of the case. The defense said the initial dissolution proceedings, they have no problem with that. But reviewing the emails and the post-resolution emails by Dan, there was no evidence that any of those were shared with Donna. The defense says that the state needs to establish this was part of the motive because their client did not receive them. The judge says the entire case file can come in. He tells the prosecution that the bulk of the files themselves, absent a connection between Donna and specifics of the divorce files, what's your position? She said there were some pleadings that aren't relevant, but if they're not connected to her, can I show them as a demonstrative aid to show it is connected to her? The judge says to show the amount of filings and volume of the case, but responses, he agrees with the defense. There has to be a nexus or a relevant connection between Donna's actions and what occurred. As to what witnesses will testify to, this file can be used for impeachment and rebuttal. So depending on what witnesses say that isn't part of the state's case in chief, may be available to them by other means not permitted by the rules of evidence. They move on to a motion in limine about the testimony of Sarah Youssef. Prosecutor Cappleman said that they have no intention to call her. The judge asked if she would be a rebuttal witness if necessary, and she says yes. The judge says if they do call her, he will issue a ruling at that time. The next motion was the testimony of Stephen Webster. Prosecutor Cappleman agrees with some of the defense motions. The testimony will be governed by the rules of evidence every other witness is governed by, but this witness offers relevant points, so she does think it should be permitted. The judge says that Mr. Webster represents the deceased, being Dan Markell. He can testify to his involvement in the divorce case and the nature of the proceedings, but he cannot give opinion without proper foundation being laid. The defense talks about some statements that were made during a meeting in May of 2014. Prosecutor Cappleman agrees these could be hearsay, and she agrees to approach if she intends to elicit a statement made by Dan to his attorney before she asks the question. The judge said if the state seeks to admit the statement, they will need to approach the bench. So as far as that motion in limine regarding Mr. Webster offering opinions, the judge will reserve ruling if it comes up at trial. As far as the motion concerning the Latin Kings being named, this is regarding the undercover officer that did the bump. The defense said it goes to their theory as to why Donna acted the way she did and the language she used on the 2016 wire calls. They would lay foundation through her testimony, but he says if the court binds our hands questioning the state's witness, It would be too late when Donna testifies. They would lose the ability to cross the state's witnesses on that issue, and it's going to be limited. For Rivera, only a few questions related to this, and possibly Charlie Adelson, depending on when the state calls him. The judge said at the last trial, the undercover officer testified he was pretending or trying to influence your client as a member of the Latin Kings gang. Prosecutor Kappelman says her argument is the same as it was in the past. The fact that he was the leader of the Latin Kings is more prejudicial than probative. The judge says for painting Rivera in a negative light, the court's ruling will stay the same. But other witnesses, if they visit this on their direct exam, once the horse is out of the barn, it's out of the barn. The defense can cross him about his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the murder of Dan Markel. As far as the undercover agent, the judge asks, he approached Donna as a member of the Latin Kings. Prosecutor Kappelman said no. Her recollection is he did not say anything to Donna about being a member of the Latin Kings. He was acting like a gang member, and she said, we don't know how well he did because Donna seems to think not well, but he wasn't wearing any clothing or anything that represented he was a gang member. He represented he was an associate of the killer who was a gang member. The defense looks at the previous testimony of the undercover agent who said at Charlie's trial that he was representing himself as a member of the Latin Kings. He didn't announce himself as a gang member. The defense says the call Donna made to him when he was verbally aggressive, that factors into his role as a gang member. In South Florida, there is a big difference between being a gang member and a Latin King gang member. The judge says this goes to your client's state of mind to establish that she knows the difference between the garden variety gang member and a specific gang member. The judge will let the defense ask if he was portraying a member of a specific gang, and depending on his answer, they will revisit the issue. As to Donna or Charlie testifying about her state of mind and knowledge of Latin Kings, the defense can visit that during their case in chief. The fact that he is a gang member can be inquired to, and his role as to why he was recruited, but mention of him specifically being called a Latin King, the judge says that's where the line will be drawn. The defense said that Donna's state of mind and level of fear was not just that she learned he was in a gang, but that he was the leader of one of the branches of the Latin Kings in South Florida, which heightened her fear, and of course, she will testify to that. The judge says he cannot make Donna testify, but if she is committed to doing so, that's her choice as part of her defense. But that also means someone with competent knowledge will have to testify to this fact. Eliciting information about Donna's state of mind from someone that has not spoken to her or has no knowledge of her state of mind, I'm not sure how that can be accomplished other than your client herself, her son Charlie, or someone else who has direct knowledge of her state of mind at the time. The defense says Rivera is under defense subpoena, so they ask he remain under subpoena so they can call him during their case in chief. The judge says, I recall him never having direct communication with your client. This is to elicit another relevant matter. And the defense says, correct. Once we establish foundation, I'd want to recall him to confirm he was a leader of the Latin Kings. The judge says Rivera will remain under the defense subpoena for the remainder of the trial. The next motion was the interpretation of the emails, calls, and the text messages. The defense says it goes to retired Detective Isom, Special Sergeant Stanford, and Jason Newland. Numerous witnesses have offered interpretation of statements made, and they're not talking about the emails, the phone calls, and the texts. They're asking the court to prohibit the state from asking someone other than an expert to offer an opinion of what someone used in a text, call, or email aside from the language Donna uses herself. Prosecutor Kappelman was like, I agree, it's not admissible. So the judge grants that motion. He says any code where a witness could lay a proper foundation on this issue Certainly, they may testify as to that point, but any general opining as to what an email, phone call, or text means will not be permitted unless proper foundation is laid by that witness. The next motion is the travel as a consciousness of guilt. The defense says, I know the court previously ruled the state can use this information. He cites some things that are laid out in paragraphs, and he stands on his motion. He said those previous pieces of information haven't been reported. I think it does go to her state of mind for making the travel plans, going to the airport, and stepping onto the jetway. The judge says Donna's prior attorney, Dan Rashbaum, said there was no process, subpoena, or warrant for Donna. The defense says he believes that's correct. Prosecutor Kappelman says this isn't new information. It was never disputed, and I don't think it changes the analysis. The judge says on this particular point, the court has reviewed the transcripts of the depositions that were cited in her new motion, and that will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as a trier of fact, will decide what significance to give to the evidence, and also the defense can cross-examine on Donna being free to travel. As to the calls and the other evidence, it will be presented to the jury as well, and they can make up their mind. The state had no additional motions they were needing to have ruled on. The defense says there was one more issue with Newland and Sanford's testimony. He said he stands on his motion. Prosecutor Kappelman says the defense elicited personal opinions from these witnesses at their deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation. And now they're seeking to suppress those opinions, which are clearly inadmissible. She says, I don't understand it. I would never elicit such a thing. The judge says if there's a basis to exclude it, it's being raised. Prosecutor says, of course, and there was no reason to elicit that at the deposition, and it could never be admissible at trial. So she says we're wasting paper and time with these motions. So there were no objections. The judge says as to any opinion that would be offered by either Agent Sanford and Investigator Newland, again, there must be proper foundation to offer opinion on a subject, and if they don't have the ability to do so, that it cannot be offered in the case in chief. The judge says we will see a context in which this might come in around either in rebuttal or as far as impeachment, but he will take that up at the appropriate time. They move on to logistics for jury selection. August 19th, they have nearly 300 potential jurors under summons, and then they will have the pre-screening of pretrial publicity. The court will ask the questions, and then the parties can follow up on the court's questions regarding pretrial publicity. If a juror is deemed suitable to return, from there, they'll be given a date and a time for when group voir dire begins. The screenings will be Tuesday and into Wednesday afternoon if needed, but he thinks they will have a suitable pool of jurors. He said if we have jurors from the pre-screening that are not suitable, both sides will have the opportunity to make their objections known as to these prospective jurors, and either they'll be excused or told to return. He mentions in the previous trial there were allegations the jurors were speaking to each other, so there will be additional bailiffs, and prospective jurors will be instructed not to talk to each other while waiting to be screened. The prosecutor asked if the judge will handle the pre-screening instructions, and he says yes. For each group of 50, he will make clear not to discuss the case or anything with each other. The defense asks how many of the 300 will come in each day, and the judge says 50 in the morning and then 50 in the afternoon. Once they get to 100 or 110, that's enough to get 12 people. The prosecution asks, how do we proceed once a jury is selected? The judge says they'll have 2 alternates unless the parties want 3. Of course, the defense wants 3. They'll swear them in, and if they have time, they can move into openings that same day so that they can move into witness testimony. As far as the state's case in chief, they estimate they will need 5 to 7 days. She said she could see it run into the seventh day, so to be safe, she's saying 6. The judge points out there is a holiday on September 1st, so they estimate August 25th through September 2nd for the state's case in chief. Prosecutor Kappelman says in the past with the other trials, they have picked a jury within 2 to 3 days. They could do openings as early as Thursday to move it on as quickly as possible. The defense prefers the day after a jury is selected for openings, and the judge says both parties need to be prepared for openings and says he will not set a time limit for their openings, but asks if anybody plans to go beyond 30 minutes. Prosecutor Kappelman says around 30 to 45 minutes, and the defense says it depends on a ruling that I guess he didn't rule on today. The defense estimates 4 to 6 days for their case in chief, and that puts it around the week of September 8th. The judge says they'll have rooms for both sides of family members. The prosecutor asked if he intends to start testimony on August 25th. The judge says if they go into Friday to select a jury, but if we get a jury on the 21st, then testimony will begin the next day on the 22nd. The defense talks about issue regarding space at their table. They say they will not all fit there, and also they don't want the computer facing people in the courtroom. She says that her eyesight is not the best, so she uses a large font. So they need a setup to keep people from seeing what's on their screen. She also mentions the microphones used to have a button you press to turn off. She said Donna is hard of hearing, so she talks loud. And she asks if they can get that function back to push the button and turn off the microphone. The judge said if Donna needs to write things down, that might be the easiest way. As far as seating in the courtroom, the first 2 rows will not be available to media. And for media, there will be 1 live camera and 1 still camera. Seating will be in all areas other than the first couple of rows for family. And the defense says Donna has family and friends who are coming to support her. So that was it for that last pretrial hearing. The biggest takeaway for me really seems like Donna's going to take the stand, and that is going to be something to watch. So that is it for now. Hope you guys have a good rest of your afternoon and evening, and we will see you soon.